this is that if you look at it, every single life matters, and every single person who goes through our court system deserves to have his rights protected. When we're looking at the concept of justice, and I want to point out the negative team never contested our goal of justice, so when you're looking at the goal of justice, we must realize that every life matters when you're looking at the goal. You have to consider qualitative significance, and the idea that it's only one person is also flawed because this happens every time there is recidivism. So I'd like to move on to the third point brought up by the negative team, which is that essentially there are alternative reasons. There are alternative reasons that people wouldn't testify. I have two responses to this. My first response is comparative advantage. The affirmative team only has to improve the system. We don't have to make it perfect. We don't have to solve every single problem. If at the end of today's debate round we make the courts more accurate than they are now, we should vote for the affirmative team. Now, my second response is 609 is the main cause. 609 is the main cause. I want to quote Professor John Bloom, who wrote, quote, "The relevant state rules of evidence do appear to be the primary determining factors in whether the defendant takes a stand. In every single case in which the defendant with a prior record testified, the trial court permitted the prosecution to impeach the defendant with his or her prior convictions. On the other hand, in the few jurisdictions where impeachment with prior convictions is not permitted, for example, West Virginia or Montana, all the wrongfully convicted defendants testified. Each of these defendants had prior convictions that in other jurisdictions could have been used to impeach them," unquote. So what we see is they looked at a bunch of people who had been wrongfully convicted and were then exonerated. And they said, well, let's look at these. In 2 states, past convictions can't be brought forth. So they compared those to the states where past convictions could be brought forth. The states which had a rule like Federal Rule of Evidence 609, everyone who was wrongfully convicted, or the vast majority of these people, didn't testify because they had past convictions. In the states that didn't allow past convictions to be brought before the jury, those people did testify. So yes, Federal Rule of Evidence 609 is the primary determining factor of whether a witness will come and testify. Now I'd like to move on to the disadvantage brought up by the negative team. The disadvantage was essentially that we need Federal Rule of Evidence 609. We need to know the past convictions because it helps determine whether the person is lying on the stand. I have 3 responses to this. My first response is look at the evidence. Look at the evidence. I want to turn your attention to a piece of evidence my partner read in his first affirmative speech. It was under a third justification, and it said the assumptions on which Federal Rule of Evidence 609 are founded are flawed. See, Federal Rule of Evidence 609 is founded on the assumptions the negative team is making, that whether someone has lied or committed, that someone has committed a crime in the past means that they're going to lie in the witness stand. But the thing is, what you have to understand is the research and the studies say this isn't true. The psychological experts say that this isn't an accurate predictor of whether someone is going to lie on the witness stand. And I want to point out the negative team never presented evidence to the contrary. They never addressed this study with this piece of evidence. Now the second response to this is that the costs outweigh the benefits. The costs outweigh the benefits. And I want to read you some evidence here talking about how this biases juries. How when you bring past convictions into the courtroom, it biases juries. I want to start with a quote from Robert Dobson, who wrote, quote, "One of the studies compared verdicts of mock jurors from 3 groups. Each group heard evidence about an armed robbery. Researchers observed that the group who heard the prior convictions or evidence was significantly more likely to convict over the group who did not hear the prior evidence," unquote. Once again, past convictions bias juries. Let's read another piece of evidence. And from Theodore Eisenberg and Valerie Hans. They said, quote, "In a study by Edith Green and Mary Dodge, 17% of mock jurors convicted the accused based on just the facts, compared to 40% of mock jurors who additionally learned of the defendant's prior record," unquote. So they showed juries, or 2 mock juries, a mock trial, and they showed them the facts. And the 17% of the people convicted the person just on the facts. This is a factually weak case. The facts didn't seem to indicate that this person should be convicted. But when you show them the past convictions, 40% of them decided he was guilty. Past convictions bias the jury. The costs outweigh any benefit of Federal Rule of Evidence 609. Thank you.
All Alright, Stephen, I trust you're having a good round. Now, I'd like to first address your talk when you talked about comparative advantages.
Sure.
And so you didn't have to prove the entire system just to have an advantage.
Yes.
Now, you still have to prove a significant advantage due to the terminology of the resolution, a significant reform.
We have to significantly reform the system
Sure.
and then provide an advantage, yes.
An advantage. Could that be saving $1?
But the affirmative team isn't saving $1, we're increasing accuracy and increasing justice.
Right, all right, but at one point is that determined at any point significant? So you,
Right.
regardless, qualitative or quantitatively, you still have to prove some element of
Right,
significance.
see, a debate round is kind of like a scale. If the
Sure.
affirmative team does more good things than bad things, or if the system is improved in any way, shape, or form, I would say you vote affirmative.
All right, now, I'm going to go over some piece of evidence that you brought up before I ask for it, though. Your evidence on your section 609 is the primary cause of that. It talked about 2 different states and their wrongful conviction rates, I believe is what it was referring to.
It specifically talked about how 2 states were they didn't allow past convictions.
Right.
The people that we found were innocent and had prior convictions actually did testify, rather than in the states that didn't actually have, that did allow past convictions to be brought forth.
All right, could we see that piece of evidence?
Yes, just a second. You can ask the next question.
All right, now does correlation equal causation?
Correlation doesn't necessarily equal causation, but when it's a really, really strong correlation, you can draw inferences.
All right, so it's based off a strong correlation. What determines a strong correlation? Is this statistics? Is this a one very clear example? What defines strong correlation?
I don't know exactly what determining factor would be anything, but there's many indications of strong correlation, and I think, and I'm not exactly sure what you're getting at with that question. So.
All right, sure. Now, talking about the flawed assumptions that you said that the assumptions that 403 that the federal rules of evidence are based off were inherently flawed,
yes.
Correct? Now, which sources were those exactly from your 1AC that said that?
Under justification 3, we read a piece of evidence from, I believe, Todd A. Berger, I believe, who said that.
All right, thank you. No further questions.
And your team take our time to do. Minute 30 remaining. Okay, no further time needed. Thank you. Okay, is everyone ready? Okay, let's begin. The affirmative team keeps on liking to bring up examples, so I'll bring up an example of my own. There was once a man, this was around the 1970s and 80s, who was a master check forger. He was able to get away with altering checks, forging checks, and basically having the checks circulate around the United States while he was the beneficiary of the money. He assumed 3 different identities. He became a JD, an airline pilot, and a medical doctor overnight. He was able to fool people. He was traveled to other parts of the world to print checks in a massive conspiracy. This man was below the age of 19. His name was Frank Avondale. There's a he's now famous for his infamous crimes that he's committed. He now works for the FBI and the check fraud department. But here's the issue, is that if to any rational jury, do you think anyone, say my age, 18 years old, do you think anyone could pull off forging checks, altering checks, moving across the world, assuming 3 different identities post-grad school while not being caught? No, a rational juror would not think that. Yet the issue is that when we're withholding information from the jury, it significantly decreases the accuracy of the judicial process. If Frank Abagnale hypothetically were to be convicted of a crime that required check expertise later in his life, and under the affirmative team's course of evidence, the juror could assume that he knows nothing about checks. Yeah, if we look at the evidence, he has significant expertise. Well, what we see is that there's multiple different problems with the affirmative team's plan. I'm going to be getting into some responses to Stephen's 2AC and then going into two inherency points, a solvency point, and a disadvantage. First off, he talked about recidivism, how we talked about there's no statistical significance because there's extremely small amount of trials that this would actually affect. He talked about recidivism and how because recidivism is a relatively large statistic, because people recommit felonies quite often, that this would actually be statistically significant. However, the issue is that Daniel in cross-examination said state-level recidivism is about 60 to 70%. We can assume that it's the same on the federal level. That is a big assumption. Federal jurisdiction and state jurisdiction deal with different types of crimes. You can't just assume that recidivism is the same on the federal level than it is on the state level. We need hard statistics from the affirmative team showing that recidivism is the same statistic on the federal level than it is on the state level, because otherwise they can't prove that their case is significant. Speaking of significance, he talked about how qualitative significance is the way to judge this debate round. Here's the issue, is that I can say, let's pass a plan to not give guns to bad guys. The thing is, it's a good idea, it makes sense, but it's not enforceable. In debate, we have more to think about than just the merits of the solution. The philosophical merits of the solution, we have to think about other things. In NCFCA debate, we debaters call this stock issues: topicality, inherency, significance, and solvency. Basically, if they're on topic, if they show that there's a bad problem in the current system, that there's a significant reform that can fix that problem, and that the problem will actually significantly be fixed, then that should warrant an affirmative team's ballot. We have to take into account other factors just than the philosophical merits of this case. If they can't prove that their case is statistically significant and is more amounts of trials, then their plan should not be passed. They also talked about qualitative significance. However, as I've already said, we can't just judge the round based off qualitative significance. The affirmative team has the burden of proof to show that their case is statistically significant and makes sense when there's potential ramifications involved. Now, he also talked about how the 609 is the main cause for defendant's testimony. My partner talked about how there's alternative causes. However, the evidence he read didn't specify which rule of evidence the defendants were acting under. They read a piece of evidence that said in Virginia and other jurisdictions where they couldn't have their credibility impeached, this was, they testified much longer. However, the issue is we don't know specifically what rules were revoked in those current jurisdictions. My partner read two other different rules, Federal Rule 608B and Federal Rule 404, that both have an effect on this. If in Virginia, for example, both of those laws were revoked, we could be having a completely different debate. We don't know the facts behind it. And also, this study was based of the 56 innocent defendants who did testify, for which information is available. Only 24 33% had prior criminal convictions. This study was based off of a number of defendants that is less than 100. The study that was based on the number of defendants is less than 100 defendants. And we can't infer a large statistical impact when we're talking about the whole federal level from this piece of evidence. Also, here's an assumption of their plan that I would like to rebut right here now. In their 1AC, they said that the reason behind Federal Rule 609 is because the past convictions have no bearing on whether someone is guilty in the present. They said this assumption is inherently false. The negative team disagrees. Past convictions bear great context into whether a defendant is guilty or not. As I already said, if someone has expertise in a certain area of crime because of past convictions, a juror might be able to rationalize, say, oh, well, they couldn't commit this crime because they don't have the expertise. If the prosecutor were allowed to admit past convictions, they'd be able to show that, yes, they are in fact guilty of this crime because they have the capability to be guilty of this crime. There's more than just truth or false here. There's there's reliability and probability of crime in that has to be determined by the juror. And also, and let me get into my inherency points. Now, my inherency point is there's already safeguards in the current system. If you look at the Federal Rule 609, it not only puts a cap on the 10-year expiration date for evidence, but it also says it must be admitted in a criminal case in which the defendant, if the probative value outweighs the prejudicial effect to that defendant, that's when evidence should be admitted. But it also talks about how for a crime in the convicting jurisdiction was punishable by death or by imprisonment for more than 1 year. Basically what we see is that they're only allowed to admit evidence of past convictions if it's more recent than 10 years old and if it was for a conviction that lasted longer than 1 year in prison time. This significantly narrows down the amount of crimes that could be admitted. My solvency point one is you're compelling people. Solvency point one is that the prosecutor can compel people to testify. The prosecutor can compel people to testify. Even if you can't ask the defendant himself whether he committed past convictions, you can ask other people whether he committed past convictions. The prosecutor can compel people to testify in a federal court of law. You can ask someone who's his closest associate, his friend, and ask them whether or not they committed, whether or not the defendant, the person, the suspects committed the crime. And if they want to likewise defend their friend, regardless of whether he's innocent or not, their culpability could be impeached, which the affirmative team is not solving for. Now my disadvantage is decreased judicial accuracy. Disadvantage one, decreased judicial accuracy. Ultimately what we see is that the defendants can get away with anything if they can't have their credibility impeached. They can assert that they're a good person, that they haven't had any past convictions when in fact they have. Ultimately what we see is that the affirmative team's plan does not uphold accuracy and is not a common sense reform. Thank you, and I'm now staying open for cross-examination.
Great. Then I just have a few questions for you today, William. My first one's about your opening story or your opening example.
Yeah.
In that story, did the man actually get caught?
Frank Abagnale?
Yes.
Yes.
Okay, great. Now moving on to my next question is, how many rules allow past convictions to be brought before the jury?
How many rules allow past convictions?
How many federal rules of evidence actually allow past convictions to be brought before the jury?
Well, 609, and my partner and I talked about how the other rules of evidence, such as 608B and 403, can provide safeguards to the potential abuse of 609.
But Rule 608 and Rule 404 or whatever don't actually allow past convictions.
Right, they're safeguards.
Right, so under the affirmative team's plan, past convictions would not be admissible.
Correct.
Okay, great. Now, my next question is, how many people have been exonerated in total by DNA evidence?
I'm not aware of that statistic.
Would you agree with me that the number is around 200?
If you provided a stats that said that, we would be happy to agree or disagree.
Okay, great.
Verifiable statistics.
Sure. Now you talked a bit about how past convictions should be used to determine whether someone is innocent or guilty. Is that the?
I didn't say in an absolute sense on whether someone is innocent or guilty, but ultimately, if you look at the jury trial, or if you even look at a debate round, you have to look at whether someone could actually commit the crime.
Right. So what you think is the negative team's argument that past convictions should be used to determine, well, as evidence to help.
They should determine. So hypothetically, here's an anecdote.
Sure.
Basically, so if someone say has a past conviction because of assault, and they assaulted someone, and let's say hypothetically they're masters in martial arts, and then when they're testifying saying they didn't assault this gigantic guy, the juror could say, well, yeah, they didn't assault him, he can't take down this gigantic guy. But if they had credibility, if they had martial arts skills, that's just an anecdote.
Now, are past convictions supposed to be used for that purpose?
Past convictions, as you already said, the purpose behind Federal Rule 609 is because that past convictions can bear a context that can be helpful for the jury.
Right, but is it supposed to be, it has the Supreme Court ruled that past convictions may not be used to help determine the innocence or guilt of a defendant.
Past convictions should not be used 100% determinatively, but it can be used in good context.
Okay, great. No further questions.
Judge, timer? I find it rather interesting that the affirmative team's goal of justice is centered around the criterion of accuracy. That their criterion, the way they decide whether or not a case or the system is just, is how accurate are the convictions and how accurate is the system. Especially when the entire purpose of 609 is to implement a more accurate system. That is its intent, and that's what it does very good in the status quo. It's a system designed to increase the accuracy of a system. So we're going to start by looking at this quotation from the Harvard Law publication talking about how 609 allows the fact finder to accurately assess a witness's story. Quote, impeachment by prior crimes could alternatively be viewed as a practical counterbalance to the Fifth Amendment, allowing the prosecution minimal latitude in telling the fact finder about the background of a defendant who chooses to step out from behind the shield of the Fifth Amendment to assert his innocence. The defendant with a criminal record is thereby prevented from presenting himself to the jury as naively innocent. The harsh truth is that all defendants have an extremely powerful incentive to tell a story consistent with their innocence. Instead, the function of impeachment by prior crimes could be conceived more broadly, to give the fact finder some background about the defendant, to provide a framework in which to judge the plausibility of the defendant's story of innocence, end quote. The prior convictions are extremely important. The entire case of the affirmative team centers around that of two major things. First of all, that the prior convictions are completely irrelevant to a case 100%. Secondly, that justice is inherently upheld better when the defendant not only can testify, but just has a slightly less disincentive to, as they would put it. These are two major presumptions that the affirmative team is putting that inherently the system is better if the defendant could testify more often, and secondly, that prior testimony literally has no effect, significant advantageous effect on the system. Until they prove that, they still cannot warrant a passing of their plan. Because in order to pass our plan, and once again, I talked about, even though they say they are upholding qualitative significance, how the quality of their plan merits passing their plan. Without proving it happens enough to where it's crippling the court system, then it doesn't outweigh the significant risk of risking the advantages currently provided by the system or the disadvantages in the arguments that my partner brought up in his previous speech. I'm going to quickly once again jump into statistics, kind of bouncing off that point, how the affirmative team still hasn't brought up statistics. The entire case, once again, the purpose of their case centers around the criterion of accuracy, yet they're not willing to provide statistics to accurately assess their case. They talk about the importance of accuracy, yet they're not giving us statistics to accurately assess whether or not their case, A, occurs enough to worth passing, and B, occurs in the exact manner that they talk about how it occurs in the status quo. They talk about accuracy, but yet they aren't accurately describing the problem. They aren't providing statistics for debate. Secondly, I'd like to talk about the alternative causes in the system. Now, they refuted this, saying, yes, these things do exist, but we have evidence that says 609 causes it more, or 609 is the larger cause, or well, the larger cause, I guess, rather than the alternative cause. There are multiple alternative causes for not testifying. There are once again, I brought up the alternative cause in the Rule 608, how one of the ways that a defendant can be impeached is just simply off of a testimony of character. It doesn't even have to be a prior conviction. So this can literally apply to any defendant, yet they claim it's only Rule 609. Also, a piece of evidence from, here we go. John T. Floyd, a board-certified in criminal law in 2014, quote, defense lawyers often advise against their clients testifying in their own defense. It is typically unnecessary and tends to expose the client to great danger. Even an innocent defendant, so much can go wrong. Pressure to induce nervousness, bad body language, poor demeanor, inability to succinctly respond to questions, etc. End quote. None of those issues, none of those reasons why a defendant wouldn't want to testify had anything to do with prior convictions. They're all other mistakes they could make while standing on the trial. Nothing, once again, had to do with alternative convictions. So there are still other reasons for why a defendant may not want to testify. Now let's examine solvency. I think we've kind of missed something throughout this round when we're talking about Rule 403. We've gone through so many different federal rules of evidence that people have gotten confused as to which does what. So let me clarify what Federal Rule 403, something the affirmative team isn't touching. Quote, under Rule 403, let me read the whole quotation for simplicity. The Supreme Court held in Green versus Rock Laundry Machine Company that not only did Rule 609 permit litigants to impeach an adversary's credibility with evidence of the adversary's prior felony convictions, the affirmative team's plan, but the rules did not permit the trial court to exercise any discretion under Rule 403 to exclude the impeaching conviction of evidence on grounds of prejudice. End quote. They're allowed to bring up conviction evidence under Rule 403. something that the affirmative team isn't abolishing under their plan. So for these issues, I strongly urge negating their plan. Thank you.
Alright, first, the affirmative team will take prep time at 30-second intervals. Second, can we have that evidence you just read and our evidence back?
The one about the Virginia.
Yeah, West Virginia and Montana.
Yeah, that.
3 minutes remaining. Two minutes and 30 seconds left remaining. Two minutes remaining. One minute and 30 seconds remaining.
Alright, just tell me when I have a minute remaining, please.
One minute remaining.
Are you guys ready?
Yes.
Timer, opponents. Alright. As Professor John H. Bloom said, quote, "Our criminal justice system and our society have committed to the principle that it is far worse to convict an innocent man than to let a guilty man go free. That commitment is hollow indeed if the current evidentiary regime is not altered." End quote. It is because the affirmative team believes that increasing the accuracy of our court system isn't done by overloading the jury with every bit of information we can, but by focusing them on the facts of each case specifically and allowing them to decide a case based on its merits rather than what a defendant did 7 years ago. There's a reason that our Constitution has a requirement that double jeopardy be prohibited in our legal system. It is because what somebody has done, once they are tried for that, that is done. They are done being tried by the court system for that. Unfortunately, this essentially allows a jury to say, we think what he did in the past is condemning, therefore we'll convict him now. This is, in essence, allowing another form of double jeopardy, and we maintain that it must be eliminated. First, I want to clear something up. Now, I believe it was Eric, actually, who read a card of evidence that said that 403 would replace 609. They underlined every word in this card of evidence except for one, and I want to read that word to you: civil. 403 applies directly to civil litigation, not criminal litigation. It has no bearing on today's round. Civil litigation is something else entirely. We're talking about when this is introduced in a criminal litigation setting. Quote, Rule 609 that not only did Rule 609 permit a litigant to, a civil litigant, which they didn't read, to impeach an adversary's credibility with evidence of the adversary's prior felony convictions, but those rules didn't permit the trial court to exercise any discretion under Rule 403. Very simply, this is referring to civil litigation rather than criminal litigation. It's irrelevant in today's round. That said, I want to address some of the negative arguments against our case. First, they said that in every federal that in response to our argument of every time there's a federal recidivism, it applies. They said, well, we need federal recidivism statistics. Never mind that they didn't give you any reason to disregard the fact that recidivism should be the same on the federal and state level. Further, the Bureau of Justice Statistics hasn't come out with a federal recidivism rate. I know because I checked. The fact is that we can assume that the state recidivism rate is the same, and even if we cut that in half, that is still 33% of cases. If we expanded it, that would make our case even more significant. No matter how far off this is, we could assume a margin of error of 10% on that statistic, and it's still a massively significant plan. Let's move to the issue of qualitative significance. Will and Eric got up and said, well, you have to consider more than the philosophical merits of the plan, which is really their way of saying, we don't have a way to beat you on the philosophical merits of your plan. The fact is, the truth is that in our justice system, in order for it to be a justice system in the first place, we have to consider every life to be of equal value, meaning that those who are convicted of prior crimes are just as valuable, their rights are just as valuable as yours and mine if we haven't committed prior crimes, because under the law, everyone is equal no matter your past. That said, I want to address a couple arguments that they made. I want to group their first, second disadvantage with their answers to our justification 3, because honestly it's all the same argument. They continue to say that, and under all of this, that you need to give context to the jury and give this information to the jury, and that'll better allow them to make an accurate decision. I have a couple responses here. First of all, cost outweighs. Cost outweighs. They totally dropped this argument from my partner in referring to earlier arguments, where he said the cost is inherently outweighed by the biasing effect. The bias contributes to a decrease in accuracy in our courts, and the bias is greater than the beneficial effect for either side. This only contributes to biasing a jury. Further, refer back to the fact that the best way to accurately decide a case is based on its facts, not on the facts of what he did some time ago. In fact, the Supreme Court has already ruled this. There's a reason that Federal Rule 404 exists. And Federal Rule 404, again from John Bloom, states, quote, this general rule is reflected in Federal Rule of Evidence 404, which for the most part renders inadmissible evidence of a person's character or a trait of character for purpose of proving action in conformity therewith on a particular occasion. Which is a long way of saying this evidence isn't to be introduced to prove that somebody committed an action similar to what they did in the past, but rather to impeach their credibility. And if you'll remember back to the first cross-ex, I asked Eric this question about 3 different ways. Is this for the use of determining their credibility? And he said yes. They have agreed. This is meant to be used by the Supreme Court, and every other legal body has determined it should be used to determine their credibility. We've shown you that's not occurring here, and that it biases juries instead. It's being misused in the misuse. Thank you. How much prep time is the negative team remaining?
A minute and 25.
I'll take that.